said, I want to dive into the special characteristics of interpreter-mediated hearings with children from the perspective of the law. Could I please ask someone to mute their mic, because I can hear a very annoying sound constantly. Yes, it's gone now. So as I said, I want to dive into the special characteristics of interpreter-mediated hearings with children from the perspective of the law. And before looking at the legal framework, I actually want to give you some context, and I want to do that by using the title of the project. And I see three specific elements, so these three distinct elements, which is children, language, and legal settings. So children, I mean, what is a child? And there's a convention, it's Convention on the Rights of the Child, which says that a child means every human being below the age of 18 years, unless under the law applicable to a child, majority is attained earlier. So why is that important, you ask? Well, for example, look at age assessment in asylum proceedings, which are, of course, debatable medically, whether they are accurate, but I mean, there you see that whether a person is 18 or not is quite important. And at the same time, I want to also nuance, because I mean, a person might be a child, but he or she might be criminally responsible. In Belgium, for example, you are criminally liable from age 12 onwards. So, secondly, language and/or languages, in fact. I think language is a central element in legal settings. It's about communication. It's also about establishing facts, and for that you need to be correct and precise in your wording. Language and languages is also a central theme to this conference. It's about involvement, about understanding, and being understood. So what then if a child does not at all or sufficiently speak the language of the proceedings it finds itself in? Legal settings, you might ask. Which settings are we thinking about? For the scope of this project, we looked at asylum proceedings and criminal proceedings. But as pointed out by Professor Dr. Liefvaart, of course, children can also find themselves in civil proceedings. Think international abduction cases, adoption, and so on and so forth. Legal proceedings are, in fact, complex, lengthy, and very formalistic. And for the people involved, especially for children, they are very stressful and they are high impact. And we know from research that command of a second language drops drastically in stressful settings. So if you bring that together, children, language, and legal settings, I think it's very fair to say that language is super important. On the one hand, you need to speak the same language, and on the other hand, of course, also understand each other. In lawyers, for example, or legal language is often very complex as well, so you need to convey a message. I think the issue of language in legal settings is often overlooked and, as a result, under-researched, and we risk to make a very vulnerable group of children invisible. Well, I mean, they are invisible up until now. So we are going to look at this issue under the umbrella of child-friendly justice. And what CHILS sought to do is we tried to gather empirical information on the right to an interpreter in relation to children. And we sought to elicit and understand the lived experiences of children under the Convention of the Rights of the Child, but also under the other legal texts that we will run through in a minute. You can see a pyramid, right? And I call it the multi-layered legal architecture. I think Professor Dr. Liefvaart, Dr. Bright have already, in a way, mentioned some documents and legal texts. And I work my way from international to national, because that's the way in which law is structured, basically, hierarchy and so on and so forth. I'm not going to talk much, actually, at all about national legal settings, because that would mean I had to dig into 27 different countries, which is basically impossible in the time span. So what we're going to look at is the international legal resources and the regional legal resources in a very tiny nutshell. So internationally, there is the United Nations Convention on the Rights of the Child, which is a comprehensive legal framework that casts children as rights holders. And it also looks at children not only as vulnerable beings and in need of protection, but also as human beings with agency, a right to decide for themselves. The key rights in the context of this conference are Article 3, the best interest of the child, which should at all times be a primary consideration. Article 12, the right to be heard, also known as the right to participation. Article 13, the right to freedom of expression and information. And lastly, the right to an interpreter, which in the Convention on the Rights of the Child is only limited to criminal proceedings. Let me read out for you a paragraph from the General Comment number 24 on children's rights in the child justice system. And this should make you understand what it means, what the right to participation means under the Convention on the Rights of the Child. To effectively participate, a child needs to be supported by all practitioners to comprehend the charges and possible consequences and options in order to direct a legal representative, challenge witnesses, provide an account of events, and to make appropriate decisions about evidence, testimony, and the measures to be imposed. Proceedings should be conducted in a language the child fully understands, or an interpreter is to be provided free of charge. Proceedings should be conducted in an atmosphere of understanding to allow children to fully participate. Next up is the regional framework. And on the one hand, we have the EU, which has a Charter on Fundamental Rights, and at the same time, lots of directives on procedural safeguards. On the other hand, there's the Council of Europe, which many of you might know from the European Convention on Human Rights. And of course, as Professor Dr. Van Liefvaart mentioned earlier, the Council of Europe Guidelines on Child-Friendly Justice. Let's have a look at the EU directives, and I'm throwing them on one big heap, even though there's many there's different scopes of application and so on and so forth. But I just want to talk about the general idea about the right to an interpreter. So who has a right to an interpreter? Victims, suspected and accused persons who do not speak or understand the language of the criminal proceedings. When exactly do they have that right? Well, during any hearings before investigative and judicial authorities, during police questioning, during all court hearings, any necessary interim hearings, or when they talk with their legal counsel in direct connection to any of the foregoing settings. And of course, I mean, a right to an interpreter or someone interpreting for you, there needs to be an element of quality sufficient to safeguard the fairness of the proceedings. So the directives also set forth that there should be a procedure or mechanism to ascertain whether an interpreter is needed. And at the same time, you should be able to challenge a decision where it is said that you either don't need an interpreter or where you find that the person who is interpreting for you is not of sufficient quality. So what about children specifically, you ask? Well, Directive 2016/800 deals specifically with children, and it only explicitly lists the right to information, so not the right to an interpreter. Why exactly? I don't know, but so the right to information, it says information should be given in writing or orally in simple and accessible language, and appropriate measures should be taken into account the level of understanding, including communication difficulties. So again, no right to an interpreter, which should be covered by the other directives, but it's a strange decision not to list that right explicitly. For criminal proceedings, by the way, there is also a directive for asylum proceedings. It's Directive 2013/32, and it offers the right to an interpreter to third country nationals applying for international protection. When do they have the right to an interpreter? Whenever necessary for submitting their case, and the directive itself specifies that at least that should be during the admissibility interview, the personal interview, where they talk about the circumstances for why they seek protection, and or during comments and clarification on the report of that personal interview. And then the directive says any other case where the national authorities call upon the applicant. What about quality? No mention of quality in that directive. So I talked about the different regional frameworks, and now I'm jumping to the Council of Europe and the European Court of Human Rights, because there was a very interesting decision by the European Court on Human Rights actually in 2018, and it concerned a case of a Lithuanian national who lived in Slovenia and was involved in legal proceedings. For some reason, Mr. Vizgerda, received a Russian interpreter. And when the court found a violation of the right to a fair trial, it underlined some elements of that case to decide that violation. And I want to highlight them. On the one hand, it underlined the vulnerability of a foreigner in a different country. And secondly, that domestic courts have a role to play in checking whether the person can actually understand and is being understood in his proceedings. And so in this case, they said that it's not only because the person doesn't say anything about the fact that he doesn't understand. National authorities also have a responsibility to check whether the person in the proceeding is on board. And what is important, I think, is to point out this case does not concern a minor, and at the same time that there's a so what if it were a minor, so to speak? And at the same time that they put an obligation on domestic courts, but arguably an interpreter is paramount from the start of the proceedings during police questioning and so on and so forth. So let me then jump to some conclusions. The right to an interpreter, yes, it seems quite clear that there is such a right and that it's relatively well established. I see it as a gateway to other rights, because if you don't have anyone who can function as a pivot between the authorities or legal professionals and yourself, then how exactly do you understand anything that's going on? And so for children specifically, who I said should be seen as active or agents in their own proceedings because they have rights, they have children's rights, they find themselves in a very difficult spot because they rely on others, professionals, to safeguard their right. I mean, someone has to make note that, hey, this child is is not really responding. So what's happening? And this goes against their right to participate. So the interpreter should be seen as a key figure in proceedings where children do not speak the language at all or sufficiently. And that interpreter can impact that right to participate in a very positive manner, but at the same time also in a negative manner. Because what if the interpreter is from the wrong region and the wrong dialect? What if the interpreter is not interpreting what the judge is saying, but is instead saying just say that you've done it, or he's maybe threatening the child? So what then? I mean, you're in a very difficult spot because the only person who can relay the information that you want to talk about is the interpreter. So an interpreter and the right to an interpreter is necessary, but is not sufficient. Child-friendly justice encompasses a plethora of safeguards and guarantees. Imagine being involved in a procedure without an interpreter if you don't speak the language of the country. Or imagine you have an interpreter but no lawyer with you who can prepare the case, who can explain you through the proceedings. What then? And for that reason, I think, as you already said from the Coal Miner 2 research, there is a need for training with professionals, or interprofessional training with every professional who comes in contact with a child. I listed some of the key legal documents that talk about this, but I think it is very well established that this is the way forward. Thank you for your time, and I will pass on the word again to Harry.